Good evening. It's April 6th, and you can't make this up. It should have been the April Fool's show because what we're going to talk about tonight, among other things, is the tribunal Boots McCormick is bringing against Fred Tricker, and this should be an election issue right here because I want you to go. We're going to go back and take you through the history, and we're going to start with Boots getting upset with Fred, but nowhere does Clay tell Fred that what he's doing is wrong. He just says he doesn't recommend it. And if you listen closely, Fred tells him exactly why he's standing up. He's not standing up to go against the board or to represent the South Walton Community Council. He's standing up to state facts. The facts that information has changed and the board made decisions without all the information. And Clay doesn't want Fred to tell the BCC that. And Boots isn't smart enough to get it. And, Boots still has a chance to show that he's not a dumbass and pull this before next Tuesday's meeting, but he won't. He'll go through with it just like he ate the bait on all that other stuff. And that's exactly what the Nick component wants. That's what Shipman and them want. They want Boots to continue to be Boots and just eat the bait. Because only Boots is the one who put this on the agenda, and Boots is the one who's creating that issue. And I'm going to let my own words, and we'll go back to that Alan Osborne show, and we'll cover that November 28th meeting where Boots lost his mind. So let's go back to that. Hold on. So here we are, and I'll just let myself narrate exactly what's happened. Watch Boots and watch $1 Million Clay not listen to what Fred says, not tell the BCC what he ethically should tell them, and he's conflicted over this very issue, some of it. And he's telling them, hey, this is an issue that Clay has conflict, and listen to what Fred said and listen to Clay's advice. Yet Fred is going to have a public hearing coming up here pretty shortly on this Tuesday. Everybody from the South Walton Community Council and everybody who's against corruption should show up to this meeting, if for nothing else, to save Fred from this lynch mob putting it on the people to take this knowledgeable man off the planning commission. So let's go over this meeting. He didn't say it was against the rules. He said they're citizens, and he said lots of other board members has wandered up here before. But Fred isn't wandering. Fred is stating a fact. And Clay didn't say Boots was doing something wrong. Or that Fred wasn't doing something wrong. He said he recommended against it. But to look at the look on Boots's face, he's clueless. Listen to what Clay said. He has the right to do so. So why are we having the hearing this week? Go ahead, Clay. Tells them they don't have to listen to it, but Fred can talk. So basically, Boots just said that he values Fred's opinion, although now he wants to fire him, but he can't recognize him as a citizen. What Boots really means, in my opinion, is we don't recognize citizens around here. You've got to be a board member, an expert, or some phony baloney person that a staff member of Clay will let stand up here and talk. But Boots can't recognize that a citizen's speech could be just as important as somebody else's. And that's what you get out of that. So let's go back to where we get to the next thing here. Where I'm going to take you to is a meeting, a planning of February 14th, or excuse me, March 14th of this year, not February. And I want you to watch. This is the further lynching of Fred Tricker, and we'll watch Gary Shipman and Mac and those people lead the way to remove Fred from the board who asked too many questions of developers. Stand by here. So here we are at the March 14th, 2024 Planning Board. Everybody knows it. Now look, the board's going to have a hearing on Fred Tricker, but they don't have a problem with Lee Perry and Shipman's connections. They don't have a problem with, I believe, Dean Burgess over there has sued the county over developmental stuff, and half the people, he's an engineer who has to sit on the other side all the time. But that's not a conflict. And real close as they take Fred apart, you'll see Lee Perry just let Shipman and Mac have their way with Fred. They've never let anybody else do that. Well, Lee, why do you think Shipman gets to talk to Fred like that? And most importantly, I want you to watch to the far left, the little county attorney. He looks like a kid. He might be 40. Who knows? Watch him sit there and scroll around and not pay one word of attention to Shipman or offer any advice to Fred or to stop this mess. He's just sitting there doing as instructed. This is what we get. This is what we pay an attorney for to be there. This is Fred's legal advice. The legal advice Clay gave him before was that Fred was allowed to talk at that meeting, but Boots is now firing him for the advice Clay gave him. Clay didn't say, I advise you not to talk or you could be removed. No, he didn't say that. He said Fred could do it just like other previous planning board members have got up there and spoke. It's ridiculous. How many times has Dean Burgess got up there and spoke about a project? But he's on the planning commission. He represents people all the time. This doesn't pass the smell test, but watch for yourself. Watch what Mac says carefully. Remember, this is Mac who lost his real estate license for fraud. He turned it over just to stop the process against him, and that's who's in charge of the Walton County plan. Go ahead. Also, watch Shipman after the Pledge of Allegiance. He's got to tell Mac something before this starts.
Remind everybody, we do have another meeting coming up this Tuesday. It's an informational meeting, but I assume it's public, right? Okay. Did everybody get a chance to read the minutes? This was from the January 11 meeting.
I did read them, and I'm gonna make a motion to approve.
All right. No changes? All right. We have a motion. How about a second?
I'll second that.
And a second. All in favor? Aye. Any opposed? Motion.
Did y'all know that Spaz Galloway came in there? You know why? Because he's got to get his orders from Shipman. That's one of the people that pulls the string. Look at him looking right at Shipman. Right here. Check it out. Anyway, yeah, Chaz, we see you. How'd you like that little dissertation I gave people? You know, you got to be careful. Or, you know, your FA and FO, you know what that means. Anyway, continue. Watch the. Here it goes. Just wanted to put out old Chazzy Poo there with his Hollywood sunglasses. Come on, Chaz.
Mac, you got something for us?
Ready to go as soon as you are.
Oh, I think Fred had something that he wanted to ask you a question about first, Mac.
Matt, if you don't mind, I'd like to get clarification on something that regards an issue that came up at the February 22nd BCC meeting on the question of legislative versus quasi-judicial. And I'd just like to get a better understanding of that discussion. Because I think that when you're talking about PUDs, you know, there's a conceptual part of that, right? Which has traditionally been handled as legislative. And correct me if I'm wrong. And that relates to the fact that within the PUD you can have things that are not consistent with the Land Development Code. You can have deviations from the Land Development Code. And that's kind of why they're legislative, I believe, isn't it?
Well, at the last meeting, our county attorney redirected us until the land development code gets modified. It says land unit developments, and it doesn't make a distinction between detailed or conceptual.
So the interim county attorney is going to tell them to do something different from the land development code until the land development code is modified. What if it's not voted to be modified? That's what I mean. These decisions are made and then they're just moved through the public just for the mere sphere of it. So it looks like that it's in a process when the decision's been made and Clay has made it. Listen to these words.
Our quasi-judicial hearings. It's a much higher standard of review, and that's the way we're going to proceed until the code is changed.
Okay, I just.
This is a chronic Walton County problem. We're going to proceed with our own procedures against code until the code is changed because Clay said so. And what's the other attorney doing? He's sitting there staring at his keyboard and scrolling through stuff. Oh, by the way, Fred didn't ask Shipman a damn thing, but watch what happens.
I'm trying to understand it because the table that you're talking about for quasi-judicial says that for PUDs, they are quasi-judicial for both planning and the BCC. But there is another table for legislative that talks about text amendments to the Land Development Code. And is a PUD not a text amendment to the Land Development Code?
If there's an overlay district, one would be adopted as a separate action.
Okay, so that's, I guess I don't understand why a PUD would be QC quasi-judicial based on that table when there's another table that says that it should be legislative.
The most restrictive of the two applies, and that is the quasi-judicial.
Okay, so the Land Development Code says that you can't take one piece of the code in isolation. It has to be taken in the context of everything else. Isn't that right? No.
Is it read as a whole? Does it have individual requirements in there? Yes, it does.
Lee doesn't like this.
Yeah.
Shipman's not been recognized. If I stood up like this, I'd be arrested.
Who has the
Listen closely.
Planning director is the primary interpreter, but I defer to our county attorney staff.
Does the county attorney have any authority to interpret the code?
He absolutely is our legal advisor.
Yes.
He thinks is different than I think. I have to go with his thinking.
Is he a land development, a land use attorney?
I don't know if I need to answer that question. He is the county attorney, and he is the supreme legal authority advising the Board of County Commissioners.
Do you get this? That Clay's supreme legal authority overrides the laws, rules, ordinances, procedures. Mac just said whatever our interim attorney tells him to do, he's going to do. Well, God, I hope Clay doesn't tell you to eat a dog turd out of the yard, Mac. Unlawful orders are unlawful orders. And you should recognize that because the LEC doesn't recognize Clay as having that role, does it, Mac? And Fred, this is why Fred is being lynched. He asked the wrong questions. And if that was me standing up in there, I'd be sat down by the cops, but not Shipman.
And as I said at that hearing, I take my direction from the county attorney. I do not dispute what he said.
Yeah, I understand. I listened to what was said and also heard you say that it was your preference that it be handled legislatively. I mean, and I heard after that you said, well, I'll defer to the county attorney. But as far as I'm concerned, the land development code says you're the authority. And I'm not really clear on what changes were being advocated. But I don't know that you need to change the code. And maybe what we just need is a written interpretation. And that becomes binding that you put out. You have the authority to do that. And why don't we just do that? Because the code's okay the way it is.
I think the code needs some time.
Okay.
I don't disagree with the county attorney. I don't disagree with the county attorney, but that is his interpretation, his legal interpretation of the code. I have to follow that.
Yeah.
I don't.
This has nothing to do with Shipman. He's not recognized. He's out of order. But watch, Perry's gonna do him one and let him up there. Buddy, his business partner. And what's the attorney telling the board now, sitting over there in the blue suit? He's surfing the internet, typing.
Anyway, I do believe that the county attorney has the authority to interpret the code. He's a lawyer, a professional planner. It is my responsibility to do that until he steps in and decides there's a different interpretation.
So I back you up on your interpretation. I think it was correct.
Well, I appreciate that. I have to go with the county attorney.
I understand that too. Thank you.
Mr. Shipman, you're a land use attorney, aren't you?
See what I mean?
Listened to it, you would have heard that the reason we went to the PUD is because there was a decision by the 4th District Court of Appeals, which you and the county commission are bound to follow. And in that decision, it was exactly the scenario where you have a government.
Listen, I guarantee you that decision doesn't say anywhere in the order that Walton County Planning Board and County Commissioners are bound to follow that determination. Because Shipman's the one's going to sit here and tell them that it's exactly like this case. And nobody's made that determination, and Shipman's just not in a position to do so. And what the hell is the county attorney letting Shipman do this and tell the board this information? Shipman is glorifying himself before the very board that he's about to present things to, and he's going to make them all feel like they've been gaslighted and they can't vote against him. Robert's over there, I don't know, he's practicing brushing his teeth or something. I can't tell what he's doing. Anyway, this is just bullshit. Go ahead.
Entity that they had in their land development code a specific procedural process for hearing a matter. I believe it was actually a cut. And the court even though it may be a legislative matter, if your land development code required that a quasi-judicial procedure be followed, you had to follow it, or it was a denial of due process and reversible error. And making that decision, the court talked about the 1973 Rinker case, and I know you heard it, I cite it all the time. In 1973,
In 1973, nobody was in Walton County presenting conceptual PUDs and demanding they had a right to a concept. What the hell? Go ahead, Red on the head.
that because land development codes and comprehensive plans and zoning regulations are a degradation of the common law. You know, we go all the way back to the adoption of the Constitution. I had to talk about that in one meeting. So people seem to be stuck on that.
Just because Shipman came to have a talk and he had to have a talk, nobody certified that as a ruling. Just because some damn attorney stood up and said something, it doesn't mean it applies to everybody, especially when this same damn attorney represents everybody who wants to do something different than the Land Development Code and Comprehensive Plan was intended to do. This is the same damn dude. Come on.
In 1791, when we adopted the Constitution, all land uses followed.
In 1791, this is the issue right now.
Well, you were free to do whatever you wanted to do with your land. So when you started adopting zoning regulations, land plan, and comprehensive plans, to the extent there is an ambiguity in the documents, which you just pointed out there is, you have to go.
Fred didn't point out an ambiguity. He pointed out that Clay overrode the actual table. That's not an ambiguity. That's bullshit caused by lawyers like you, shithead. Swear to God.
Most favorable to the landowner. And that's what we did. Now, Clay Atkinson, the county attorney, was presented.
In Walton County, what's most favorable to the landowner is to not to give the planning board and not to give the commission and not to give the public all the real information when something's got to be passed. That's what's most favorable in Walton County.
With a case that is directly on point from the appellate court in the state, and is
Said
provided
who?
to the county, they must follow that regulation, just like you must. And if you don't, you are violating that landowner's due process rights guaranteed under the United States and Florida constitutions. So no, until it changes, any PUD is quasi-judicial.
And that applies to both the conceptual and the detailed reviews? All conceptual reviews?
All reviews of PUDs.
Shipman doesn't answer the question. It's about concepts.
And understand, quasi-judicial is a procedural. There's actually,
Conceptual was invented by Mac. We never used to do that.
Disagree with me on this, and legislative, it's still a hearing. There is still a procedure that you have to follow. We tend to not do it in this county, but there is a procedure. If you do not follow the procedure that is adopted by the county, you have violated the landowner's due process. And that's what that 4th District Court of Appeals case stands for. And to the extent that there's contradictory procedures, the Supreme Court, 51 years ago, has rendered a decision that's not been changed since then, that you have to you have to follow procedures most favorable to the landowner. It's a procedure.
And the other aspect of that too that came up at that meeting was whether the evidence had to be competent and substantial. And the answer was no, it did not.
No, it didn't. That didn't come up.
It absolutely did. I'll go back and
Brad, I'm the one that argued it. All quasi-judicial is competent and substantial.
I know. You're right about that. I'm not arguing that. But Mr. Atkinson said at that meeting that in this case they would be, I think he called it deferential evidence.
Although in that particular one at that meeting, you may recall, Mr. Tricker,
Tricker.
The sole issue was whether or not that PUD could exempt out having to have a component of commercial, which every single witness, even the people that were anti-development, said they didn't want commercial in there. So not only was there competence substantial, there was clear and convincing evidence on the particular issue before the county commission.
Now, when Shipman has somebody that says something against his, he doesn't say those people are clear and convincing. He says they're not experts. But when they testify in his position, they're clear and convincing witnesses about what's going on. This is what the problem is. And why is our county attorney sitting there still hadn't even mumbled hello? Shipman knows he's not going to say shit to him. Shipman doesn't care what the county attorney's doing because he knows that that guy's not pulling the strings and Shipman's going to do what he wants. He knows who he's got in his pocket. That's my opinion.
The reason for the PUD, the reason you follow that process is so that you're actually addressing the issue.
Somebody feed Robert Nelson a cookie.
Not all these other things.
But that specific issue is a legislative issue. It's a policy issue. It's not whether or not it confirms the comp plan.
Oh, Mr. Tricker, the courts disagree with you. When you get a law license and you start practicing law, I guess you can appeal it.
Well, I don't think we need to have the decision on this tonight.
No, we don't.
You're right. Matt,
Could
you
I
got
offer
something?
one clarification? Mr. Tricker referencing 1.08.00, the interpretation section of the code, and he was referring to subsection. The elements that make up the Walton County Land Development Code are interrelated and cannot be interpreted in isolation, must be interpreted within the context and meaning of the entire code. However, the section C, right before that, says whenever any provision of the Walton County Land Development Code or any other provision of any other applicable law, rule, contract, resolution, regulation of the state of Florida or federal government contains standards covering the same subject matter, the more restrictive requirements shall control. That's exactly what's happening here.
Okay.
Thank you.
All right. Let's get started with the regular meeting. Matt, what's on the agenda?
We've got a long agenda.
So here we get back to the meat of the matter. They want Fred gone because Fred asked questions. Fred told the truth, and go watch what Fred told them. And watch Clay's actions. Fred told them that the BCC was making a decision off of information that had changed since it went through the full staffing process. It should have been pulled. It should have been. It shouldn't have been forced through. But it was Sandestin, and Clay was not going to let something have a chance at that. Fred knew. Fred was the only one who had met with the previous county administrator and met with the previous county attorney that had admitted they did not have the paperwork to show Sandestin standards had been changed through an NOPC process or court. And therein lies the problem. Fred told them new information was uploaded to the county after the board met, and that the project had changed. How much clearer can Fred get at being a citizen or a board member for that fact? And Clay clearly said this is something other board members had done before, just like Fred was doing. But why not the lynching? Why not the concern over the relationships on that board? Why no concern that Mac's running things who gave up his license for fraud? Fraud accusations from the Realty Board. He can't ever get it back. I mean, don't these developers have Mac in a pinch? Because he can't go back to his other job as a realtor. He'll never be one again. Isn't that a conflict for us, the citizens, that we have somebody who can be cornered because they got to have their job? What kind of shit is that? And we don't even know what the findings will be of Mac's AICP. His certification, there's been a complaint filed. So, I mean, this is bullshit. This is what bullshit looks like. And the only way we can, if you're out there saying, I agree with you, Alan, y'all come up and look at who's going to want to serve us citizens if we let a man like Fred, who has no agenda but to do the right thing and preserve Walton County the best he can for the people who live here. And for that matter, the people who visit here. Water quality, traffic, compliance, these are things important to us all every day because everybody moves throughout Walton County. But that's the way I see it on the Alan Osborne Show. We got some problems out there, but go watch that county attorney's behavior. Look at Fred being fed to the wolves, and who's going to volunteer to do that when you're going to get somebody standing up there treating you like Shipman is, telling you something from the 1700s and that you better obey or else? Or is it or else what, Shipman? They'll send Chazzy Poo after us, the Tiger King, the pre-filed District 5 candidate. Let's see if Chaz stays in the race. And let's see if Charlie Simmons jumps in where Teddy and Hamilton are running in 3 for Barker's old seat. Watch the good old boys scramble. To hell with Godwin and those people. If you watch that part of it, you'll understand. All those people benefited by helping these people who have special rules. We're going to go over some of that stuff of what's going on in law enforcement in Walton County. And I'm going to take information that comes from you, the viewers, and I'm going to cover it. And no, I ain't going to tell you which viewers give it to me. As long as it's credible information and it can be confirmed, we're going to cover it on that. And it's going to leave some marks. But go watch this lynching of Fred. Show up on Tuesday and tell the commissioners, you've got way worse conflicts in planning and the planning board and the process than Fred Tricker. He's the citizen up there standing up for us, for gosh sakes. Don't take the one guy that's willing to say, hey, what's this? That's the way I see it on the Alan Osborne Show. You can't make this shit up. Like I said, we got a lot of subjects to cover up coming up here soon. And we'll see you next time on that. And tell a friend to watch this. And tell somebody to come vote. Come to a meeting and stand up if you're new and ask questions. And if you just moved here, if you like your taxes low, you better get some of these jokers out of office because they're going to break us all. And that goes all across the nation. It's awful what's going on. If you were a conservative, you should have been at Matt Gaetz's dinner last night in Walton County, where he said every 100 days we're taking on $1 trillion in debt. And you know how much of that goes to other countries and this border issue and all the stuff that Biden's doing? $1 trillion. We're handcuffing our grandkids to a problem that we should be solving today. And that's the way it was. April 6, 2024. See you next time. You can't make this shit up. Tell a friend.